Hi, I'm Meredith Duncan, and the purpose of this module is to provide you with an overview of the typical first-year law school curriculum. Before I get into the specifics of the courses themselves, I want you to appreciate that every law school is different and has different requirements for their first-year law students. So it is impossible for me to tell you exactly what courses you will take and when you will take them. That being said, law school curricular courses have been pretty consistent, dare I say stagnant, for a very long time, consisting of a pretty predictable slate of first-year required courses. The courses first-year law students take, and when they should take them, have long been criticized as being both too doctrinal, meaning that they emphasize thinking like a lawyer too much, as well as sorely lacking practical skills courses designed to turn out graduates who are more practice-ready. In fact, it wasn't until very recently, over the last few years or so, that many law schools have made an effort to incorporate more practical skill courses into their first-year curriculum. Even so, the traditional first-year curriculum, as I'm about to describe to you, continues to have impressive staying power. So here's my handy-dandy explanation of the courses you are likely to take your first year. These courses are legal research and writing, criminal law, civil procedure, contracts, property, and torts. Now, of these 6 courses, legal research and writing is unique in that it's a skills course in which you will learn how to conduct legal research and compose legal writing. Because it is such a different type of first-year course, in this video series, it gets its very own module, which will be presented by Professor Coughlin a bit later. In this module, I will provide a brief discussion of the remaining 5 courses, or the Big 5 as I like to call them. The Big 5 are typically doctrinal courses whose primary purpose is to teach the particular substantive body of law. Let's start with criminal law. Much of this course will focus on the 2 central components of most criminal offenses, the mens rea, or the state of mind, and the actus reus, the criminal act. Modern-day criminal offenses must be clearly defined by statute, so this course will also necessarily require you to learn how to interpret statutes as well. But this course will be so much more involved than that. This course will likely take your thoughts to places they have not had the opportunity, time, or inclination to go. For example, you will likely consider thought-provoking and challenging topics such as why we as a society punish, who we as a society should punish, what does and should criminal punishment look like, and how long should we punish for commission of any particular offense. You will likely also have an opportunity to study at length the history of the criminal law in our country, including its genesis in the English common law and how that law shaped most current modern-day criminal law statutes. You might recall my description of our common law system in a previous video module covering the structure and role of the U.S. courts. Your criminal law course will be unique from the 4 other members of the Big 5 because it will focus, well, on the criminal law. What I mean by that is that it will focus on the criminal law as distinct from the civil law. Let me explain further. You likely have heard of some crimes just by reading or watching the news, right? Crimes such as murder, robbery, or theft are common examples of crimes you are familiar with. What you may not have appreciated is that although individual people may feel victimized by another person's criminal activity, crimes are technically harms against society at large. Therefore, it is the government that prosecutes alleged criminals, and it is the government that seeks to impose sanctions for violations of the criminal law, sanctions such as imprisonment. This body of law, the criminal law, is to be distinguished from the civil law, which is in large part enforced by private members of society rather than by the government, who have been individually wronged by other members. The remaining 4 law school courses you are likely to take your first year in law school will concern civil matters rather than criminal matters. So moving on to the first of those civil action courses, let's talk about your civil procedure course. All civil lawsuits are controlled by a set of procedural rules. Although each state has its own set of civil procedure rules, in your first year you are most likely to study the federal rules of civil procedure. This makes sense because most state civil procedure rules closely follow the federal rules. In your civil procedure course, you will spend a lot of time studying the text of the rules themselves, but you will also study cases that develop the key concepts, such as which court has jurisdiction to hear a particular case. Does the court have jurisdiction over the parties before it? And which court system's rules of substantive law should apply? Students often find civil procedure to be one of the most difficult first-year courses for a number of reasons. First of all, the subject matter is unfamiliar. The need for persnickety rules of procedure is not as intuitive as the need for homicide law, for example. Second, the rules can be quite technical and filled with unfamiliar terminology. For instance, I remember reading the word interrogatories for the first time and wondering how in the world to even pronounce the word. An additional difficulty is that the rules of civil procedure usually have to be interpreted in the context of litigation involving other areas of law. So you may be studying cases concerning contract disputes or tort disputes in your civil procedure class, while at the very same time in another class, you are just learning what a contract or a tort is. A challenge indeed. Another course that you're likely to take your first year of law school is contracts. Your contracts course will focus on the formation, performance, and breach of oral and written agreements, otherwise known as contracts. Much of the course will focus on the 3 essential ingredients to the formation of a binding contract: offer, acceptance, and consideration. 3 simple words with infinite permutations. Unlike civil procedure, contracts will likely seem more relevant to your everyday life, especially once you appreciate that we all enter into contracts most every day. It may just have never occurred to you before entering law school that this is what has been happening. Ordering a meal at a restaurant, or using your debit card at a grocery store, or entering into an apartment lease. They are all contracts. After taking your contracts course, you will see contracts everywhere. Another course you are likely to take your first year is property. In your property course, you will study the principles of law governing the ownership and transfer of personal and real property. Personal property is stuff that you can move around and that is not attached to the land. Real property includes land and structures actually attached to the land. Most of your course will likely focus on real property. Your property course may prove to be challenging because much of property law is filled with alien concepts and seemingly antiquated terminology, such as adverse possession, easements, restrictive covenants, the fee system, and the dreaded future interests. But one of the things that first-year law students find to be most comforting about their property class is that in this subject area, there are more definite, correct answers to legal questions. Unlike many other areas of law, where there may be no one right or correct answer, in property, the rules are more black and white. Once you master the property rules, you may find the course to be more understandable and comfortable than courses with more abstract legal rules to apply. So far, we've discussed your criminal law, civil procedure, contracts, and property courses. Rounding out the big 5 1L courses is torts. You may not have ever heard the word tort before, or you may confuse it with the dessert, which is a tort, which has an E on the end. But I digress. You may be wondering what a tort is, but I would guess that this is another area of the law that you have some familiarity with, whether you realize it or not. Torts are everywhere, and this course, much like your contracts course, will make you see torts everywhere. When a person is physically or emotionally injured, or her property is damaged through the wrongful conduct of another, the potential for a tort suit arises. So if you have ever heard of the McDonald's hot coffee case, you have heard of a tort case. Or if you've ever heard of a patient suing a doctor for medical malpractice, you've heard of a tort case. A tort is a civil wrong other than a breach of contract for which the law allows the plaintiff a right to money damages from the wrongdoer. Professor Levitt is going to speak to you at length about tort law in the next module, so I'll leave that more detailed discussion of tort law to her. First-year courses are the critical building blocks of learning, not only the fundamental principles of law in core subject areas, but all of your first-year courses begin the process of training you to conduct legal analysis. These courses begin the process of molding you into the competent, knowledgeable, and successful lawyer that all first-year law students set out to be. So that's it. A quick guide to the first-year law school curriculum, the building blocks for a successful law school experience and legal career. I hope this has been helpful.